I would love to introduce y'all to Safia Council, who is our next speaker. Safia is a legal professional, but also loves video games and horror. So, yeah, that means in the daytime she's working on NDAs, music licenses, terms of service, and all that fun legal stuff. But at nighttime, she's digging Dead by Daylight, 7 Days to Die, writing fiction, and also, fun fact, she loves turtles. So, can we please see some turtles in chat as we welcome Safia to the stage?
Hi, everyone. Welcome to Know Your Music Copyrights, Work for Hire versus Licenses. My name is Sophia Council. I am an associate attorney at Frankfurt, Kernet, Klein & Seltz in the interactive entertainment and advertising groups. We'll be going through copyright law, just the very basics that you need to know as a musician and really anyone who's creating art for a living. All of the things that I'm going to be covering in this slide are applicable to you because there are licenses for many different types of work. There are work for hires for many different types of projects and services. So everything I'm really going to be covering in the slide can be applicable in other contexts. Just a disclosure, this is not meant to be legal advice. If you have any legal questions, please consult an attorney. This is really just for educational purposes. So we're going to be going over copyright law. Then I'm going to talk about specific clauses in license agreements and work for hire contracts, and really talking about some specific legalese that we use. These clauses are really boilerplate for these specific types of contracts. So really, if you're getting a license agreement or a work for hire, hopefully that you walk away with knowledge of what these terms mean. And then I'm going to briefly talk about the O'Donnell Salvatore Incorporated versus Microsoft Corp controversy case. It's not, well, you'll see at the end. So for US copyright law, it's different. Different countries have different types of copyright law, but specifically for the US copyright law, because we're in the US and I'm a US attorney, it protects an original work of authorship fixed in a tangible medium of expression. This law, these rights are actually baked into the Constitution. The Congress has the power to protect the instruments and the arts of the artist or the author, and that applies to patents and copyrights. So it gives the specific copyright law gives the copyright owner, which isn't always the author of the work. It could be the person you're entering into a contract with, which we'll see later on, gives them the exclusive right to copy, reproduce, and create derivatives in the work. A work can be really anything that is listed in the copyright law. For the context of this, for purposes of this discussion, music, the composition. The composition is the composition that the master recording, as well as sometimes choreography, can be considered a work that is copyrightable. It lasts for the life of the author plus 70 years. It can be transferable. You can assign your copyright. You just have to update the Copyright Office, or if you have an actual registration, you can operate at the Copyright Office, or you can have just an agreement between yourself and the other party, and just keep those records just so you know that you've assigned those rights to someone else. You're not required to register your copyright in order to have copyright rights, to have copyright in a work, but it helps if you need to sue someone for copyright infringement. You really need to have that registration on hand in order to actually have a case. So what a copyright isn't, it isn't a trademark, it is a patent, and it isn't an idea or savoir-faire. Don't really know how to pronounce, if I'm pronouncing that correctly, but savoir-faire is really elements or themes that are customary for that genre. For example, a zombie in a horror movie, in a horror game or a horror movie, you really can't create that off the top of your head. It's zombies are just go hand in hand with like horror. So now we're going to go into the clauses. So first, the next terms I'm going to be talking about is the grant of rights and ownership. Those really answer the question of what is the artist getting and what is the artist giving up. So for a grant of rights, here is a sample clause or boilerplate language, really. I'm not going to go read it out. There's a lot of words in this presentation. I don't want to bore you, but really, I think one of the main terms you can focus on are the limited, revocable, and non-exclusive parts. So limited means you can't do everything with the work, with the music. There are certain limitations on your rights to use the music. So usually you see this kind of language in a license agreement because the artist is retaining the work. Revocable means that the contract can be canceled. Not the contract, the license can be canceled, rescinded, revoked. Non-exclusive, maybe you want to give other game companies a license to use your music. So you might want to put non-exclusive. Sometimes you would put exclusive. Usually you put exclusive if you're trying to make more money off of that developer. Otherwise, it doesn't really make sense to have an exclusive agreement with a game company. For this one, really, right title and interest, it's pretty self-explanatory. Just fancy words we use to just say everything that can come with the ownership of that work. Any future rights in that work, any derivatives, any ancillary rights in that work, those are going to be retained by the artist in a license. Goodwill is the inherent value or recognition. Like if you're a famous composer and you have like a specific type of like style, the goodwill associated with that work is retained by you. It's not going to automatically go to that developer. For work for hire, it's different because usually for work for hire, you're getting paid for a service. And at the end of at the completion of the services, the work is owned by the person who paid you. So usually the author is the developer or whoever hired you to do the work. As you can see here, they become the sole and exclusive owner, usually, of the copyright in the work. And you can't make any claim to ownership of it or any moral rights, usually. And what's interesting is this is all boilerplate, as I've said before, which is just like standard contract language you'll see in contracts. It's moral rights is a concept that's not really recognized in the US. It's more of like a UK European concept. However, you will see that usually in like a work for hire agreement in the ownership clause, just because you never know. We like to cover all of our bases when we're writing these contracts. And the moral rights refers to like right of attribution, right to prevent people from revising or altering the music. And to maintain the integrity of the work. So the next topics I'm going to be talking about are what are the artist rights. So these are going to go over derivative and ancillary rights, what those mean, briefly royalties, and just like some other terms that you as an artist may try to seek as you're working into these contracts and trying to put all like these things that you want to make sure that you're getting once you sign the contract. So royalties, compensation, and credit. So derivative ancillary rights. Ancillary rights can be like DLC if there's any like additional content, because normally when you're making a license agreement, you're really covering the game unless the game is defined as something else that encompasses downloadable content down the road. Film and TV adaptations, book adaptations. If they're making a film or TV adaptation and they're using your work, that's an ancillary right that you want to make sure that you're covering and that you're being compensated for as the artist. Or if you're if the developer, you want to make sure that you're able to use the music that's been affiliated with the game in the film and TV just because they're really related, they're part of the same universe. Derivatives are works that are based on or incorporates the work. A sample or remix is outside the scope of this discussion, but these may not fall under derivative rights. Sync royalties, they're more for, they cover like the public performance right of a copyright. So if someone's performing your music in some bar, your video game music in a bar, do they have the right to do that? And should you be getting paid for that performance? Usually you have to make sure that you are assigned to a public performing rights organization in order to really collect from these types of performances. And usually the venue has to have an agreement, a performing license agreement with these PROs in order for the PRO to collect on your behalf. These are sync royalties. It's kind of a gray area with respect to Twitch, YouTube, video game streams. If someone's playing a game and your music is you can be heard over the stream, usually they don't have those organizations, those platforms don't have agreements with the performing rights organizations. So usually those platforms have DMCA, which is the Digital Millennium Copyright Act. They have takedown notices or those kinds of procedures in place so that you as the artist can say, oh, they're using my music or they're playing my music without my permission. But usually in the actual license agreement, they will say the developer will try to incorporate these rights and make sure that they're being covered if someone is supposed to be streaming and they're creating videos. Mechanical royalties are really with respect to physical and digital copies. That includes Spotify, but not Pandora. Still very confusing issue for me, but usually the real difference between Spotify and Pandora is you can choose which song you want to listen to on Spotify, but you can't choose which song you want to listen to on Pandora. It's really broadcast. So Pandora would be covered on the public performance royalty angle, but not from the mechanical royalty angle. And the mechanical royalties can be self-collected or through an administrator. For the master recording royalties, you can have master recording royalties if the music is being streamed on Spotify, for example. I've also included total buyout or installments. How are you going to get paid for the work that you're doing? Make sure that would usually be in the license agreement and the work for hire. In-game credit, do you want to be credited for your work? You'll see it less so with work for hire agreement, but you'll more commonly see them in license agreements. And free game copies. Do you want a free game for all your work? That's something some people try to get as well in these agreements. What happens if a third party sues the artist? So this is a pretty standard indemnity clause. For the longest time, I didn't know what the difference was between saying indemnify, defend, and hold harmless, but they actually mean completely different things. So I'm going to share that with you right now. Indemnify, really you must pay and reimburse the other party for losses. Defend is provide for any defense, such as paying for legal representation in the case of a litigation being brought against that other party. And holding harmless means you assume responsibility for any of your acts that cause the other party to be sued, and you promise not to sue the other party after the fact. Usually, one of the major kind of triggers for this indemnity clause is a breach of their representations or warranties. And so for an artist, the representations or warranties is everything you've created is original to you, or you have a license to use like a sample or something in your music. And there's no third-party samples in the music that would come back to hurt the developer for including your music in their game. What type of damages are available? So this is another pretty standard thing. The developer wants to protect their game, their products, their services. So they want to prevent the artist from seeking any kind of equitable relief, such as an injunction, which can be a temporary restraining order or permanent injunction, something that will prevent the developer from exploiting the game. Or equitable relief could also be an example of equitable relief. Specific performance could also be an example of equitable relief. And it's really it's an order requiring that person to do something. So the developer really wants to limit damages to monetary damages. Usually, because this is a contract, you're getting paid for services. It's understandable, really, that the developer would want to limit your damages to monetary damages. And something that's important to know for injunctive relief, in order to be eligible for injunctive relief, it has to be a situation where the injured party cannot be compensated for the loss. So you can't, like, money won't fix it. But in these cases, because it's a contract, you're getting paid, usually money will fix it. If you want royalties, that's money. So this is pretty standard, and most of the time, a lot of artists will just kind of agree to it. Can the artist transfer their rights or obligations? So this is an assignment agreement, which is normal for just like a lot of contracts. Usually, more so on the developer side, they want to limit the artist from being able to assign the rights or obligations of the artist to another party. And that's because the artist is if the artist has like a special skill and you're able to create like this great video game music, you don't want to, as a developer, you don't want to see that the artist has assigned the agreement to someone else who's doesn't have the same level of skill or doesn't have produced the same type of music as the artist, as you. So usually you'll see an assignment agreement where you're going to have to the parties agree to provide prior written consent to obtain the prior written consent of the other party before making the assignment. And once the assignment happens, the agreement is binding on the parties, so between the artist and the developer, as well as the person who the rights or obligations are assigned to. So this is O'Donnell Salvatore Incorporated versus Microsoft Corporation. So and I think this is a great example of why it's important to know the differences between these terms, the differences between a license and a work for hire, the language, just so that you're more educated and kind of understand know the red flags and make sure you're there for every step of the negotiation and that you've got the rights that you want to end up with in the end. So in this case, O'Donnell and Salvatore, which are two musicians, alleged that Microsoft owed them royalties and credit for Halo music dating back 20 years. And O'Donnell and Salvatore sought to block the release of Paramount Plus, not Paramount Plus, but the Halo TV show that was on Paramount Plus. That still is. I think it still is on Paramount Plus, as well as obtain royalties up through the Halo Infinite game for use of their songs from 20 years ago. Their basis was that their company, O'Donnell Salvatore Inc., licensed the music to Bungie. However, Microsoft took the position that since O'Donnell was a Bungie employee at the time he created the music, although he created it independently as part of O'Donnell Salvatore Incorporated, that his work was a work for hire. And so if it was a work for hire, as we've just discussed, Microsoft would own the rights in the copyright. They would be the authors of the copyright. But if it was just a license, O'Donnell Salvatore Incorporated would retain the rights in the copyright. And usually if they're retaining the rights to the copyright in a license agreement, and especially you can try to, you have more bargain room for royalties and the like, and any additional compensation for ancillary rights or other things that the developer wants to create using your music. As of April of this year, the lawsuit was amicably resolved, but I just think that this is a good example of everything we've talked about in this presentation in practice. So I'm opening the floor to any questions. Here's my email and my Instagram if you want to just DM me for questions, but I am in the chat and just waiting for any inquiries or comments that you may have on the presentation.
Thank you so much, Safia, for that wonderful talk on copyright law. I'm sure a lot of folks learned and appreciated said wisdom. And if you did, definitely be sure, if you want, to share that knowledge out on the Twitters or Facebooks or whatever platform it is that you are most on. Use our hashtag gdocExpo.